the fats, and it was good. I mean, it wasn't just it wasn't for the taste of it, and of course. Learning to make a pie is on my list, my mental list. My mother has passed away, but. Good morning. May it please the court, Elizabeth.
Could you hold on just 1 minute? We want to get this on tape. Okay, proceed, please.
Good morning. Elizabeth Doherty for the appellant Ronald Billings in this case. This case presents the same question as the case preceding. In fact, involves the same detective in the same city of Brockton. I would submit that this case presents the question of harmless error, and for which the court has to look to the other facts apart from the tainted evidence, in this case the drug certificate, to determine whether the admission of that tainted evidence created harmless error, or that the error was harmful. In this case, I would submit that the other evidence in this case did not establish, did not render the admission of the drug certificate harmless.
Now, in the last case, I gather, he said, "I field tested, it was positive." In this case, did he state the results of the field test?
No, Your Honor. And in fact, this case is a much weaker case than the case preceding, and in fact a weaker case than the case of Conley, in which Conley, the officer, testified to the result of, I guess, two groups of substances, several substances in each case.
Couldn't we assume that if it was not, if the field test was negative, that they wouldn't go forward? Isn't that implicit?
Well, that's true, that from the continued prosecution of it. But there have been a number of cases from this court saying that that's not enough, that's not enough, that doesn't overcome the most powerful evidence of the nature of the substance. That is, and in that particular case would be Commonwealth versus Charles, I believe, talks about, while it can be inferred, it doesn't overcome It's not the overwhelming evidence of the nature of the substance to overcome the error of the tainted evidence. So, no, I would say that it doesn't. Yes, the jury might make that inference. But in this case, where there is no evidence, there is not overwhelming evidence of the nature of the substance, the jury at the same time might have, as I suggested in the brief, the jury might have inferred, perhaps, that the result of the field test was negative because they didn't submit it. I would submit that this case, to some extent, is akin to the field testing in Fernandez. In Fernandez, if you recall, there was an instruction to the jury saying that this evidence, the evidence of field test, was said to be incremental and was only cumulative of other evidence.
It didn't use the word presumptive?
Yes, they did. I was getting to that. Yes, they also said that it was presumptive. So the jury was instructed to that. So in this case, there was no evidence of the field test, and so it stands on the same footing. And in Fernandez, if you recall, the court determined that the evidence in that case, even though there was evidence of a positive field test in that case, where in this case there's no evidence of what the result was, it's akin to that. It's treated the same way, I would submit. I would also argue that two things in this case. First, that on this particular case, on the facts of this case, because there is an absence of field testing, because the other...
Well, there wasn't an absence, just an absence of what the result was.
Absence of the result, yes. But there's an absence of the mere mention of the fact that a field test was conducted is not the overwhelming evidence of the nature of the substance that, to overcome the weight of the certificate. But in addition, even if I would submit that even if this court finds, notwithstanding the absence of field test result in this case, I would submit that field test evidence in of itself is not the kind of overwhelming evidence to be a critical factor or the determining factor in a harmless error determination. Because of the problems with it, because it's been unreliable, because it's presumptive. But I would also submit that it's the field test evidence, particularly it could be in a different case, on different facts. But in this case, the field test evidence is akin to the conclusory opinions of the nature of the substance that have been found to be inappropriate, that have not been found, like in Nelson, that there's no evidence as to the procedures, there's no evidence as to the type of test that was used in this case, there's no evidence as to the conditions that it was performed.
Do we have any unique circumstances which, when matched, added to the field test, might support the conclusion that this was a drug?
In this case?
Yes.
In this case, no. I would submit that there's not. The defendant made no statements. He made no admissions. And getting to some of the issues that Judge Cordy was asking in the case before, not contesting the nature of the substance is different than a case where someone completely concedes the nature of the substance or stipulates to the nature of the substance so that to make a personal use case as opposed to distribution. This is not that case. There are no statement. There is one statement from the defendant that Detective Morrissey says he asked him to get the rocks for him, and the defendant says in response to that, according to Detective Morrissey, I'll go get the rocks for you. That's the only statement from the defendant. There is no, there's no admission that he would make, in order to make a personal use case. There is no opinion testimony from the detective in this case. He was not asked to opine about the nature of the substance, and he did not offer any observations about the color or appearance There was not an instance where there was a user who had who could testify to that. I'm trying to think of other things. There was no visual identification, and this court and the appeals court has really only assessed visual identification or sensory identification of marijuana, not a white powder, as in this case. Well, it was rocks, but there hasn't been any difference between crack cocaine and white powder. So to answer your question, no, there is not other evidence that would establish the nature of the substance here. But as I say, I would also submit that the absence of the result distinguishes this case from Conley. So on that basis, the court could find that there wasn't overwhelming evidence of the nature of the substance to render the harmless error.
Did the officer say, was there any testimony that the officer said it appeared to be rock or crack cocaine?
No, there was not testimony that he said that it appeared to be. There are some cases that this court has talked about where it said it appeared to be. No, he did not. He did refer to it in the transcript. I think once or twice he referred to it as rock cocaine. But I would submit that that falls under the sort of, that would be a conclusory opinion. He gives no basis for his statement. And so I would say that it would not be an accepted opinion for that reason.
Are you ever aware of any case where where a court held that a police officer is competent to testify that something is crack cocaine based on its appearance, and that was actually a litigated issue at the trial, not just something that was glossed over? I'm
not, Your Honor. I mean, most of the cases do talk about that visual identification of indescript white powders is not sufficient. I have not. I'm not aware of identification of crack cocaine versus a white powder, but it's white. It's a powder, just in a different sort of a congealed. It doesn't have any, no distinguishing features to it or anything like that. So, and I would get back to the evidence in this case. He did not offer an opinion as to what this substance was, and in fact, as Justice Botsford pointed out in the case before, just as in that case, he was really there to testify on the distribution element, not on. And he did not testify that he was qualified in narcotics identification. He was really there to testify primarily on the role of runners in street-level drug distribution. And in fact, if you look at the transcript where he talks about his qualifications, that's what he would be qualified in, street-level identification. He does not give any qualifications as to narcotics identification. If the court has no other further questions, I will rest on my brief.
Thank you, Counsel.
Okay.
Good morning. May it please the Court. Mary Lee, Assistant District Attorney for the Plymouth District for the Commonwealth. I would note that in this case, the defendant continually refers to Charles, saying that the certificate was the most significant piece of evidence in the case. But in this case, I would suggest the prosecutor at trial did not even think that was the most significant piece of evidence. It was not referred to in the opening or closing. And in fact, when you read the transcript, you'll see that it's Detective Morrissey's testimony that is the most significant piece of testimony, because it contains the defendant's admission, and we're calling it an admission, when he says he's going to go get the rock. And Detective Morrissey testified in his expertise what the rock means, and that means crack cocaine. It's not just cocaine, it's distinct from powder. Rock means crack cocaine. And the defendant said he would go get the rock for the
But if he was selling a beat bag, he'd say the same thing.
Well, I suggest that we certainly don't want to discount the significance of an admission by the defendant. For example, in an armed robbery case, when the defendant says, I've got a gun, whether anyone sees the gun, that has very powerful evidence. evidence of operation in Leonard. I was driving the car. That wasn't sufficient in Leonard because it wasn't corroborated. But here it is corroborated because it's not just the defendant saying it's crack cocaine. It is the police officer saying it's crack cocaine. He testifies to that at transcript page 52. He calls it independently himself that it's crack cocaine. And then again at pages 54, I believe it's, yes, page 54 of transcript 2, when he's identifying the substance so that it can be admitted into evidence, he's already called it crack cocaine, and the prosecutor says, you indicated that an individual spit out a piece of rock cocaine and handed it to you. Is that accurate? Yes. May I approach? I'm approaching you with a glassine bag. What do you recognize that to be? And he says, that is the $20 bag that I purchased from Ronald Billings. So here you have the officer independently calling it crack cocaine, and then during identification, he's identifying it. Granted, in answer to a leading question.
There's no evidence that he, of actual training about identifying, I mean, in comparison to the case, maybe it's McDonald, I forget the name, about the marijuana.
The sufficiency of the evidence on the marijuana, that is McDonald, yes. And he gives his expertise. He doesn't talk about his expertise in field testing. I'll grant you that. But then we have to go to Delbert. We have to look at the Delbert line of cases. In this court's...
Let me just interrupt your flow for a second.
Sure.
Was there any testimony about how many cases he had been involved in? Like
Yes.
hundreds of cases
Yes.
over 30 years?
11 years. He'd had narcotics training. That was described. He'd done 1,000 narcotics arrests, and he'd been permitted to give expert testimony before. And then he went on to give expert testimony, and it wasn't just about what a runner is. He talked about rock, what does that mean? He talked about drug deals on the street, and then he talked about doing his undercover drug deal in this case, because in his narcotics arrest, he oftentimes was an undercover officer as well. So a great deal of experience, but I acknowledge to the court not specifically on field tests. So then you look at Delbert. Well, under this court's 2010 decision in Barbosa, this court said, if, as here, there is no motion in limine and no invocation of the judge's gatekeeper role, the expert's opinion may be admitted in evidence. And so,
I'm not suggesting it's not admissible. It's
no.
a harmless error.
So then, when it comes in, it's coming in for its substantive worth. This is substantive evidence. This officer is saying this is crack cocaine. How do you know that he knows this is crack cocaine? Well, it goes along with all his experience of what crack cocaine deals are, and he did a field test on it. And he's cross-examined on the field tests. Counsel asked him, were there any other tests that, aside from the state lab, there were no other tests on this evidence, was there? And the officer said, I did the test on it. And he goes, oh, the field test. And he says, yes, the field test. So, and you find that, I believe it's at page 71.
What was the evidence, if there were any, about repeat transactions, either in the future? This was a one-shot deal.
This is a one-shot deal. Yes. This is at the Alamo Cafe in Brockton on Legion Parkway, and the undercover officer, who's the detective who testifies, drove around, made eye contact, comes back around. It's got a big median strip in the middle. Comes back around, and he's radioing. I think I can make a buy. Comes back up. Defendant comes over from a group of 4 or 5 and says, what do you want? 20 or rock? He says, give me the money. He says, I want to see the stuff first. So defendant goes over to the group of people, comes back very quickly, spits it out of his mouth. This is all as crack cocaine deals are done, and they make the exchange, $20 for the rock. And in that time period, he says, I'll get the rock for you. So what you have here is you have the defendant says it's crack by calling it the rock. You have the cop says it's crack. How would he know it's crack? Well, he did a field test. He's got a lot of experience in crack. He purchases it for crack, and he calls it crack to the jury. And he's asked to identify it, granted through a leading question, but he's asked to identify it as crack. I would suggest that evidence is what the prosecutor argued. That was the strongest evidence in this case.
Can I ask you, I take it you take the position that even though the certificate was objected to on hearsay grounds, that it's not preserved error? Because if it's preserved error, obviously it's
Yes.
a prejudicial error standard.
Oh, the certificate was objected to for, are you talking about the drug certificate?
Yeah.
The drug certificate was objected to for redaction of his name. I don't believe there
Was
was
it a hearsay objection?
because that was one of the issues that was raised on appeal, and I have it. I thought it was just for redaction.
I take it would still be
and it
harmless
was
beyond a reasonable
redacted.
doubt standard, but I just was curious as to whether you felt it was preserved. You're saying no because he got his redaction, that's really what he was looking for, and the objection didn't go beyond that.
Right, and the defendant had raised that on appeal, and I submitted the records to show that it was in fact redacted, and the defendant withdrew that claim on appeal. And so I thought, you know, my memory is, I'm getting,
Your memory's
getting to
better
the
than ours.
age. I'm getting to the age where I don't trust my memory like I used to. So
How do we know that the field test was positive?
I think it's when you look at evidence, you look at it for what it's worth. It was not contested, and the officer testified that it was crack cocaine. I think it is implicit in his testimony that his field test was positive.
He testified that it was crack cocaine? When?
Yes, he did, at page 52. He was identifying the defendant, and he said that's the person I purchased crack cocaine from, and he independently called it crack cocaine himself. So I would suggest that this case is right in line with Conley. It's not in line with Fernandez. Fernandez had a Daubert hearing, and the defendant is not making a claim for this court to make a determination that field tests are not admissible in Massachusetts or are not reliable or only admissible for limited purposes. And they're correct to make that concession in their reply brief because this court is not a fact-finding court. This court has never been presented with a record of factual evidence to determine what is the status of this unreliability. You don't know, are people calling this unreliable because of too many false negatives or too many false positives? You don't know if an officer can do more than one test or if there's a particular brand of field tests that are more reliable than others. You don't know any of those materials, and so the defendant appropriately does not claim that this court should be saying or ruling that field tests are unreliable or only useful for presumptive evidence because you have not been presented with that record. The defendant has provided hearsay that is not part of the record as part of their brief. The Commonwealth has made a motion to strike that information because there has never been a Daubert hearing, and under Barbosa, it is too late to have one now. So this evidence came in for substantive purposes. And even if you only want to look at it as corroboration for the officer testified substantively. This is crack cocaine. And you want to know how he knew? He did a field test. You want to know how he knew? He bought it at the Alamo Cafe. You want to know how he knew? It was part of a regular crack deal, just like Commonwealth versus Pimentel. It's corroborative.
So if this case had gone to the jury without the certificate, you're saying there's no doubt in your mind that a jury would still find beyond a reasonable doubt that it was cocaine based on the officer saying it was and the fact that a field test was conducted?
I'm saying there's no doubt in my mind, but all I have to show to this court, my burden is to show that it was harmless beyond a reasonable doubt and that there's no, I'm not going to say the words properly now that I'm trying to restate it, but that you can be sure that this verdict would be the same without the certificate. And I would suggest to you, yes, because all the evidence at trial.
It's unattributable. Unattributable.
Unattributable, yes.
Certificate.
Yes, it's unattributable, yes, and I appreciate it, thank you. Unattributable to the drug certificate because the defendant says it's crack and the cop says it's crack and they both have good reason to think that it's crack. One's the seller, the other one did a field test, and the whole thing looks like a crack deal. So I would suggest to you that that evidence is more than sufficient on the Lattimore standard. It reaches the standard that you have been looking for when you are looking at Conley, and this case is right in line with Conley. The only thing that we don't have that Conley has is the actual result of the field test, which I suggest is a reasonable inference and implicit in the officer's testimony.
Did the judge give an instruction with respect to the use of the drug certificate to the extent that it was prima facie evidence and the explained prima facie evidence in terms of the jury could rely on that alone?
Yes, he did. Well, he gave it that it was prima facie evidence of the substance's composition.
Doesn't the judge's instruction in conjunction with the certificate sort of place the drug certificate on a much higher level than the other evidence, the field test and the statement by the police officer, which, as the jury knows, they could reject, they could accept it, they could reject it in part. The judge sort of put the the instruction on prima facie evidence puts a little bit of a thumb on the scale, doesn't it?
Well, I might be worried about that if the prosecutor was even making any reliance on the drug certificate in his closing argument, but he wasn't. I mean, he was saying, listen to Detective Morrissey, and Detective Morrissey is, testified. I mean, there were other people who testified because this is a school zone case. There are other witnesses. But when you're going to what is this substance, he was relying on Detective Morrissey and the defendant's statement, and I would suggest that that shows that all the evidence at trial is lots of evidence besides the drug certificate is showing that it's crack. And if you take the drug certificate out, it's more than sufficient. And I would suggest, even with that instruction in there, that this meets Conley, it meets Casale, and it's distinguishable from Nelson and Fernandez, because it doesn't have that Fernandez language about the limited use of the drugs of the field test, and so then the field test is admissible for its worth because they didn't bring a Dalbert motion, which they could, but they didn't, and that leaves them without a claim up here that this is an unreliable test. If there's any further questions, I'm happy to answer them. If there is not, I would ask this court to affirm the conviction, and I would ask you to allow the Commonwealth's motion to strike those documents from the defendant's record appendix.
Thank you, Counsel.
Thank you.
Is Judge Swank with us?